here I am in Sunshine State where I grew up. I left Florida when I was 24, I think. Number of reasons, one of them being a girl. It's a very common story in Austin. So I wanted to talk about the G-Files a little bit, walk around the neighborhood, recording myself, have everyone look at me very funny. I had a couple of thoughts on this. Well, it's no secret that G-Files are going to be released. Exactly which ones, we'll find out. It's going to be expensive, and I kind of know why. Are the costs ridiculous? Yes. But I think I will get into why I think they're going to be expensive, why they are expensive. There's a lot of problems with this, you know. There are parts of a G-file that meet a criteria of information that has already been ruled as confidential and not subject to public disclosure. So, there's a couple of Supreme Court cases that happen if you start reading on the Open Records Act and how it came about and how these landmark cases came about and how the Attorney General ruled after it, before it, after it. A couple of things get put in the way. There was a famous case, I'm trying to remember the name of it. It was basically a industrial group, I think it's Industrial Foundation versus something. It's a famous case where an association has something to do with industrial workers that was not very pro-union, wanted to do an open records request on I think it was a union, I believe, or some state board. Trying to pick up the specific details out of my head here, but it was basically injuries and all types of weird stuff for workers' comp claims. And, you know, the argument was, well, this association just wants to do some union busting. And so, you know, they went to court over it. Bunch of shenanigans ensued. It eventually reached, I think, the Supreme Court of Texas. And, you know, the concurring opinion was, you know, you can have that information, but if there's certain elements that are met, certain information should remain confidential. And one of those elements is something, you know, like intimate and highly embarrassing, like who you're dating, who you're seeing, your genitalia, what you're doing with it, photos of your genitalia and medical reports, things like that. And, you know, the court said, if it meets that criteria, I'm sorry, it doesn't really have a public interest to it, that can be withheld. And I think that's going to come into play in this G-file debate, because there's also I can't name the case, but I think it was also an opinion that came out that has been cited widely about interagency communications, and how if you ever done open records requests with emails, you know this, there are certain matters or affairs that government bodies do, and they often email each other saying, hey, such and such happened and I'd like to get your opinion on this, what do you think I should do? And I think a previous court and Attorney General ruling said that those are matters of frank discussion among employees that are not purely factual or cannot be de-intertwined, I think the word was, from known facts and events. Basically, it's some I'm kind of using my own words here. It's some sort of like advice, you know? And that if everyone knew that every single email, every portion of it would be public record, people would not ask for friendly advice within their agency to figure out what to do in certain circumstances. So that's sort of like a protection. So certain, obviously events and facts cannot be redacted, but internal processes and understandings or advice or frank discussion can be, because it's protected, at least under the Texas Open Records Act or Public Information Act. So that's one thing. And then there's something I think it's probably been covered in a court case before many times, I'm sure, but something that hasn't really gotten a lot of discussion is that, when officers do administrative or get called in for an administrative investigation, I think it's important to distinguish between administrative investigations and criminal investigations, because the two are very different. And rights at I shouldn't say very different, but they're different insofar as, in a criminal investigation, just like any other defendant, you can remain silent. You can request an attorney. You can have, such as, the same rights everyone else has, for criminal investigations. G-files, for the most part, there may be exceptions, do not pertain to criminal investigations, if they are deemed a G-file after the investigation, I guess you could say. They're administrative investigations, violations of policy, or things that are not violations of laws, but violations of policies that an law enforcement agency have, or things like that. And so with that in mind, there's a distinction, and a lot of police agencies have said, hey, since this is just an administrative matter, I'm going to order you to talk about what happened very frankly, and even against your own self-interest. So I don't know if coercion is the right word to use for it, but they are compelled to speak. And that's very different from any criminal investigation, where you generally are not compelled to speak unless you're in court or something of that effect. So an administrative investigation, they are compelled to speak. And I was thinking about this. I was like, you know what? Now this is completely different, but there are some very similar circumstances. When you go into a therapist, obviously the goals and initiatives are different. But if you think about the legalities here and the framework, when you go into a therapist session, there is an implied understanding, and many times a written understanding or verbal understanding, that what is said, unless there is some severe violation of law in which they're required to disclose to the authorities, such as suicidal ideation or child abuse or elder abuse, things of that nature. Anything that's said in a therapist session is implied to be confidential. And if the therapist, for whatever reason, decided to go spill everything you said out on the internet without your express permission, there would be some problems. It may even be against the law. May even lose their license. So when these officers are doing administrative investigations, or subject to them, I think there's an argument to be had that they had a reasonable expectation that this was confidential. And how do you break a confidentiality agreement? What are the provisions for that, right? Well, obviously, if it reveals something very criminal, then I guess it could, right? A very compelling interest, right? But if there isn't that element, you're kind of breaking a confidentiality agreement. Implied, probably. It may even be written down depending on how they sign and administer these investigations. And, you know, it's an interesting question. Like, what? If you compel, I don't want to say force, but you compel someone to speak, quite frankly, about what happened, because the nature of the job does require a level of honesty among the chain of command to be like, hey, just tell me what happened here. You know, like, obviously you're not going to go to jail for it unless there's reason to think that. I just want to know what happened, why you did it, and, you know, let's move on. We could, and to add to that, it would also be like, hey, you know, if you violated policy, yes, other people are going to know about it, but you know, if it's something small and it doesn't really violate policy, it's going to be confidential, whatever you tell me. With that with that implication or implied understanding, and then you come out and you say, well, we recorded what you said verbatim, and now we're going to tell everyone, even though there was no finding of wrongdoing. That's a problem. You know, I guess voters could change that, right? If a bunch of people come together and they say, hey, we're all going to vote on a measure that makes such and such not confidential anymore. This is where it gets even more tricky, because this government code 143.089, I think it was, I forget the exact code, local government code. The G-file thing is a state law. And if there was a state petition, I guess, that amended that, well, I guess, and the voters voted in the affirmative, I guess I guess the voters spoke, right? This wasn't a state election. This was a local election that was going to basically, in effect, change state law. Now we're onto something tricky here, right? What is going on? And there's a lot of arguments about, well, the state law was they may keep a G file. I don't think that matters. State law is the state law. And I guess generally you could increase more, maybe, I guess depends on, I'd have to look at more laws, more precedent, but you can't just say I'm going to change it a little bit. You can't change state law unless you go through the state law channels. Very tricky here. If state law says may such and such, can a local law say shall such and such? Like, how little can you change a state law by not going through a state law process, right? So, alright. I guess that's my thoughts there. I mean, there's a lot, you know. And then we have matters that are intimate, as I discussed before. If you have something that's an intimate matter, right? A person's own relationships, who they're dating, who they're seeing, their friendships. I mean, it's possible to get that information through an open records request, but there would have to be, previous courts of, you know, opinion, and the Industrial Foundation court case, you know, it has to meet a certain like, I think it's like a 3-prong or 2-prong test, where it's like, it has to be a matter of a public interest. Like, you can't just, there's lots of documents that have people's intimate details that are under government control, and that's what public information, well, that's what government information is, But public information would be something the public is allowed to see. And, if there's elements of, people's intimate lives in there, that generally is not considered public information unless there is a public interest in knowing that information. It has to meet a certain test, the balancing of the scales got to say, hey, this may be intimate knowledge, but this is something that is within the public's interest to know, such as a crime or something quite compelling. And, these G-files are not investigations of crimes generally. That's why they're categorized as G-files. And most of the time, they're not even violations of policy. They are a look at a possible violation of policy. And many times, not violations of policy, and have elements of it that, not always, but very often have frank discussions about what to do and how to do things, which is interagency exception right there. And then, intimate and personal details of a person. Sometimes involving their wife, their children. You'd be surprised how much officers mention their wife, their children, or who they're dating, who they're talking to. Even friendships are a part of that. And many officers are friends. I can understanding who is friends with who. An agency can be important, but it would only be important if there was some other reason for that, like a crime or some type of corruption or systematic violation of policy. So you have all these other elements that make any record exempt, not just G-files, which previous courts and Attorney General opinions have, state courts have said, district courts have said, yeah, that's not public information, that's exempt. But then a local election there's just so many weird things going on here, and I really hope that the attorneys present it in such a way, because they're going to present it as, I don't know how they're going to present it really, and then the court looks at the arguments submitted and says, well, you can't go against the equity action lawsuit under these grounds, right? So I hope they bring forth, these are compelled statements against their self-interest. These are matters that can be highly embarrassing or intimate. They can be interagency discussions. They're supposed to be frank and allow for good discussion about things that are non-factual or cannot be de-intertwined from factual or event-related information. They don't involve a crime being committed. And they likely, for the most part, followed policy. Is there a compelling public interest to, release that information? I mean, even at the very least, even if G-files are allowed to be released, that's why they're expensive. Because all these other tests that have to be conducted on, whether information is, in its segregated parts, is public or exempt. So every statement, every sentence an officer makes has to be aligned under those tests. And has to have a lawyer or two to take a look at it and go, ooh, if we release that, does that meet this test? Because if we release that, that could be a problem. even though the whole file itself is, technically, according to the district court in Travis County, is public information. Even, it's just a mess. I think there's a lot to unpack here, and this is not the end of it. They filed in Supreme Court. They went to appellate court for a stay. They denied it, and I guess at some point they're going to go to, well, it was an intervener. Intervener wanted to go to an appellate court. And then I was looking at the case file. He went to the Supreme Court, and haven't really heard anything from the Supreme Court yet. And they move really slowly, so we'll see how long it takes them to come back and say, well, we've looked at this. Yeah, it's a mess.